Hey, everybody. Well, welcome to the next show. This, of course, is Doc G, and my next host is actually his own show, Foreclosure Defense 101 and more. Welcome, Coach Neighbors.
Hey, everybody. Thank you. Welcome to Smoking Bacon Radio.
And yeah, our new partner.
Yep. And we're here to make it happen today. And we just want to make sure that all the people listening to Smoking Bacon Radio know that it's going down right now.
We're ready to go to school, aren't we, Coach?
Yep. So you guys better bring your notepad and take some notes, because there's going to be a quiz later. And if you guys don't get it right, we're going to make you run. No, actually, if you don't get it right, we're going to make you go start packing. Okay, never mind. That's kind of a funny joke, but not okay. Let's move on.
Or no beer, because you're not gonna. Yeah.
Yeah. Well, we don't have nobody packing at my program, so I can make that joke. Hey, did you have your lawsuit dismissed for failure to state a claim? Did you think the judge threw you under the bus? Well, today we're going to review that, exactly what that is, and we're going to talk about some other things that you need to look out for when you're in the process of filing your own lawsuit. Now, this program today, we're going to cover how to state a claim, what you need to do to state a claim, and this is going to help not only people facing foreclosure, but it's going to help anybody that's filing a claim in court or had their claim dismissed. Because the way we put it together, you will be able to change the things that you need to change to make this fit for your situation. That's what we do here. So before we get started, I wanted to take a minute to go over a couple of things. People that are doing the lawsuit packages and filing your claim, we want to make a couple of changes. I want you guys to add to your $5.5 million lawsuit claim. We want to add the fact that you are also including the attorney's assets, their bar card in your lawsuit. So you want to include those things, because remember, you're going after the attorney and not the lender. Because, okay, so people get this mixed up. This is like the second biggest mistake. The first biggest mistake is people think the lender's coming after them in foreclosure, and it's actually the attorney. Now, the second biggest mistake is kind of the same mistake, but I'm going to put it to you a different way so you can understand it better. A lot of people get the two processes mixed up: the foreclosure and the mortgage loan. They are not the same thing. Okay, they're not the same thing. They're not the same problem. So most people go into court fighting the mortgage loan, and that's what they're fighting. They got the lender as number one defendant, and the lender has nothing to do with the foreclosure. So we need to change the way we think about this and the way we're handling it. Okay, the lender has nothing to do with the foreclosure. And if you don't get that right, you will be packing, because you will get hosed. And what they do is they let you flop around in court till you run out of money, or until they get tired of dealing with you. And then they throw your case out for a failure to state a claim. Now, what I'm going to teach you today is not going to help you if you don't have the right person as the number one defendant. The number one defendant is the name that's signed on the document that started the foreclosure against your property. So that's the name that you need to have as number one defendant. Now, if that person got rid of the stepped aside and there's another attorney involved, well, then you need to have the name of the attorney that's actually facing you in court, or the name of the attorney that filed the last notice of appearance. So let's listen to what
Rudy's right here.
Before we get started.
Rudy, are you there, Rudy? Okay, Rudy, go ahead. Let's hear your story. Go ahead.
Well, several issues. I had the hearing at the eviction court, and he denied my jurisdictional objection, but luckily HSBC Bank has a moratorium till January the 31st of 2021. So he couldn't do anything.
So Rudy,
Huh?
we did last week. We did a show on the jurisdictional challenge, and the issues that we're having with that is that when people file it, they don't keep track of the amount of time that the other side has to respond. And if you don't file your notice of default or whatever you need to do, if the other side don't respond, then the judge thinks you're waiting for him or her to rule, and then the judge rules. Now, when the judge, if you read jurisdictional challenge with an affidavit, if you read it closely, you will see that you are ordering the judge to make the attorneys respond and prove jurisdiction. What the court do is the judge will try and twist it and say, well, you're expecting the court to prove jurisdiction and blah, blah, blah. And that's not what you put in the document. So at the end of the day, as soon as the judge throws you under the bus, you have to file for reconsideration and attack the judge with a motion to recuse or something. You can't let it slide, because actually, if the judge dismisses the motion to jurisdictional challenge with an affidavit without jurisdiction, because the judge is not the one that has to prove jurisdiction, it's the other parties. And if the judge does that, the judge has put himself or herself up for a civil lawsuit for violating your constitutional rights for taking jurisdiction when they had none.
Yes.
So that's what you have to do. If they deny your second shot in the door, you have to do something about it, because the judge does not have immunity. The judge has qualified immunity if they're following the law, and they're not following the law because they have you in an administrative court from the get-go. And they have you in a court that is not connected to the Constitution, and that's why they don't have to give you any rights. So in order to get the rights, you have to back them up and cost them money and let them see they're about to get sued.
We'll take another call if somebody wants to call in. You know the number. Okay, Coach. Any reflection on what he's saying? Because he's saying that I think he got confused with the counterclaims. Is that correct?
Correct. And so he said he filed the jurisdictional challenge with it after it happened, and this is the mindset that people have to change. That people kind of have a problem with going after the judge, and sometimes it takes people getting slapped in the face a couple of times by the judge to figure out that the judge is not fair. And until you address the judge's violating the administrative process, then you're going to still. Once they see that you're not going to do anything, then it's on, and so he's catching up now. But that should have been taken care of at the time. That's a big deal. If the judge dismisses your jurisdictional challenge with an affidavit that was set up for the other side of the parties proof, the judge is obviously helping them, and you got to step up and address it right now. It's the best thing to do, because as soon as they violate you, if you address it at that time, then they'll respect you. Get to the point where they don't respect you, then they'll just keep on smacking you in the face until you force them to respect you. And now it's a little bigger hill to climb to get that respect, because you got to do all this stuff and start over and do all these things. And and not everybody not everybody has that killer instinct kind of sort of,
Yeah, I was going to say.
So this is a quick story. I boxed for a few years, and I won a tough man contest in 1985 up in Kansas City. And my coach used to always, when I was training to get in the contest, I got in the Golden Gloves just so I could have some experience, So I had my first fight. This guy shows up, and he always wins. He always gets the trophies because there's nobody in the heavyweight division.
Right.
And he was a little overweight. Don't look like he ever lifted a weight. And I was like, oh, this is going to be fun. So it was time for a match. And my coach was like, Neighbors, I want you to knock this guy out. And I'm like, Coach, I'm not going to knock him out. And all the guys were like, what? I was like, dude, I'm not going to knock him out. Coach like, Neighbors, what is your problem? I was like, Coach, do you realize how much crap I put up with from you? So there was nobody big like me. So he put two small guys in the ring that I had to box two people at the same time is how he got me. Yeah, it worked.
Yeah.
But at the time, so I told him, you have any idea how much crap I put up from you? And these two people beat me in the ring and stuff. I looked at him, I said, I'm going to enjoy this. This is going to be nice and slow. And that's kind of the way I roll. I like to make them give up, because when they give up and go sit down, you ain't got to worry about the appeal and all that other crap. When they can't respond, they're done. And that's what we do.
Coach, I think it's like you said. I think it's more a battle of wits. Who's going to withstand? Who's going to hang in there the longest to try to at least stop what's going on? If everybody would just stay in the game, play the game, they would probably. It's almost like the game where you stare at a person and the other person can't stare at you, and then you win. It's like that. If you just keep staring at them and telling them, listen, I'm not backing down. I'm not leaving. I'm doing what I want to do. I'm staying here. They really can't do anything.
You got to stay in the ring.
Right.
And cost them money.
Right. And the more money you cost them, usually you become a person that just push aside and say, you know what? We'll go get somebody else.
And the reason that is because they have so many people that give up. And now you're blocking them from getting 3 or 4 more people that were ready to give up, people that they didn't have to fight.
Right. That's right.
And stand in the ring. That's the biggest thing. And people don't realize that. If you are set up to where you're willing to do whatever it takes, then you stay in the ring. And other thing that, and I have this as a note to bring up, don't allow their limitations to interfere with your program. Now, I had a lady tell me yesterday, the judge said I was a fictitious litigant, and the judge said I couldn't file anymore. So if you follow what the judge said, then the judge don't have a problem.
Right. That's right.
You have a problem. If you do what you need to do, then the judge is going to have a problem. You already have a problem that you're trying to take care of.
Right.
So I tell people, if you get into my program, don't come in my program telling me about, what the judge said or what this. I don't, when we're not doing anything, I do not connect what I do to what you were doing already, because what you were doing already is fraud. And no matter how you do it, no matter how you squish it up and work it, you still got a pile of crap.
Right.
It still stinks. And then you got stink all over your hand and all over everything else that it touches. It's like COVID stink. Okay, never mind.
When you get going, man, you don't stop.
Yeah, you get carried away.
You're like that. You pull that little strip, and then you're gone, man.
But I get people all the time. I had one guy who's telling me, okay, they got in the program, they're in the online course, but they're not doing what I asked them to do. And, we're going to keep doing what we're doing now because I've been in my house 11 years doing this. And then we're going to save your stuff for a nuclear bomb. And I'm like, dude, so you're lucky to be in your house 11 years and your road's running out, or you wouldn't be calling me. So if you're in my program, I'm the coach. We're going to do things the way that I think we need to do them. And if that's a problem, then I'm going to coach you. And that means that I get to be grumpy. A little grumpy. And then people, like I said, one day the guy told me, well, you need to relax. Well, I won't be grumpy until you tell me to go sit down, and then I'm going to go sit down and leave you alone. But the thing is, you paid me to coach you and help you. So I wouldn't be doing my job if I said, okay, well, you're right. I'm going to let you keep doing what you're doing over there instead of getting on this whole new program and filing your lawsuit against them and making all that stuff have to shut up. And so, for me, I don't even want to work with you unless you're 100% ready to rock and roll. So if you're not 100% ready to do what we need to do, then I'd rather just have you go over there and do whatever you want to do. And I'll take the next person in line until you're ready to do what we need to have done. Because at the end of the day, it's my reputation, my program on the line. And at the end of the day, I'm just going to go right out here and say it. I don't like to lose. I do not like to lose. And I take it personal.
Right.
If you don't do what you need to do and they kick your butt, I take it personal. And maybe I shouldn't if you're not doing what I ask, but I still do. And I have a hard time with it. And I've had more than one person that told me I need to relax. And a month or so later, and they didn't implement the program like I asked, like they're supposed to. People don't realize that this program that I have put together was put together over helping people over different states for a long period of time. And we got to see how they responded. We got to change things, and we got to try this, try that, and see what's, So we have a program put together, and it's hard for me to explain it to everybody. But if you don't follow the steps, when you get down here, you're not going to be in a position that you need to be in if you don't follow these steps over here.
Right.
So people have a hard time realizing that. And I get a little stressed out sometimes because people think they have, I got 10 days to answer. I got this, I got that. Okay, you do if they're following the rules. But they ain't following the rules, and that's why you called me, because they're not following the rules and they're killing you.
I did want to ask you a question, though. Does this also work for businesses? Because right here on the East Coast right now, we're having a lot of problems with businesses, 25% capacity. Their business people are getting ready to throw them out of their place. Does this work for businesses too?
Like commercial foreclosure?
Yeah.
Yeah, I don't see why not.
Wow.
I don't see there's any difference. I haven't done an actual commercial foreclosure or work with one, but from learning how the process goes, from the paperwork and all of that, it's the same. In the end, it's done with the note, and there are probably some, for businesses, because they're usually more and you have to pay longer. But yeah, I don't see why it shouldn't work for a business as well.
Okay. Yeah, because I had a lot of friends ask me that, and I said, well, I'll ask them. I think she's calling now. Let's see who it is. Coach Neighbors Show. Who's calling?
Hey, it's Ron. How are you?
Hey, Ron. How are you? Are you calling Coach Neighbors Show?
Yes.
Okay. What's your question, Ron? Or comment?
Forgive me, I was unable to get on a little bit earlier, and so you might have covered this. But question on this, I'm very new to this in terms of what you're specifically talking about. And I've got an eviction pending after judgment and everything else. I'm in a judicial state, and I'm also on appeal. So the trial court doesn't want to touch anything, while I'm on appeal to the giving up the jurisdiction to the appellate court. So can you address that at all?
So if you're in the eviction process, I have a document that you can use to actually attack the whole thing. It's the jurisdictional challenge with an affidavit that we've been talking about, and pretty much everybody that's used it is smiling. That document is priced right now at only $200, but you have to send me an email if you're interested in it, because I don't have it posted on my website, because it's a document that I put together for the online course students. And I actually put 2 more documents together for the online course students too. So they still have something special. So I've been allowing people to use this one document because it's pretty badass. The eviction process.
Hold on, he's not done. Go ahead. Go ahead, finish, Coach Neighbors. Go ahead.
So the eviction process, you should challenge, if you've got your lawsuit filed, then the eviction process has to hold, because the eviction on immediate possession, and immediate possession has to take a back seat to a title dispute. So if you got your lawsuit filed, so what you got filed waiting on appeal, did you have an attorney?
No. So I'm appealing a motion 60B that was seeking to overturn the confirmation of sale. I've been into this actually for 15 years, if you can believe it or not. So I'm going around and around and around and around. So I've done different things, and but I'm still there. But they gain a little bit each year, so to speak. So they finally got to the point of getting the sale of the house sold, and then the confirmation of sale. So I filed a motion 60B to overturn that because there's numerous flaws, and of course that was denied. And now I'm trying.
So the Rule 60B you filed for the failure to state a claim.
No, he didn't hear you. Go ahead and say Coach Neighbors again. Go ahead, Coach Neighbors.
Rule 60B, failure to state a claim.
Well, it tells him that I was citing the issues that I believe that the court got wrong by denying my motion 60B, if that's what you mean.
Okay. So when you say motion 60B, you're talking about your motion to dismiss or failure to state a claim.
Not so much the underlying state claim, because absent something that you're talking about, this jurisdiction issue, I've already, that ship has already sailed, and so the house is already sold, the proceeds have been distributed. So now I'm trying to fight the confirmation of sale, and I have a number of different things I can do to do that with. But
no, Ron,
Yeah.
You're missing a boat here. It's never over. You can challenge jurisdiction of the sale up to 15 years after the judgment. So it's not over.
Well,
15 years after the judgment, and that's actually written right in the document that I'm talking about.
Ron, let me not interrupt Coach. I don't want to interrupt Coach, but I want to say congratulations on 15 years of them not stealing your home. Okay,
that's good. That's good. That's good.
That's something that a lot of people don't do. Go ahead, Coach.
No, you're right. Congratulations on that, because that's quite a feat.
Ron, go ahead.
Well, yeah, and so it's been good in that sense. And yet at the same time, I'm now sort of at the phase where I want to win on principle, not just on other issues. So, before it was a struggle for survival with all the kids there and all that, but now it's kind of more or less just, I want to win for the sake of winning. If that makes any sense.
Well, Ron, you should. My website's at winincourtnow.com. You should go to my website and check out what I have put together. If you scroll down, you can see the questions and answers that most people asked. If you scroll down further, I have some of my Google reviews pasted in there, and also some videos from my YouTube channel, which I offer free information to anybody on the channel that can take it and use it for what they want to do. If you need help, I have the documents on the website also. But the document that you need to get control of that, if you sent me an email, my email address is winincourts and the number 1 at gmail.com. So it's WINURTS and the number 1, winincourts1 at gmail.com. If you send me if you're interested in it, you can send me an email address and let me know you're interested in the jurisdictional challenge with an affidavit, and I'll send you a link. I'll send you a link to it. I think I probably should just go ahead and post it on my website because everyone's using it.
Are you seeing win as in versus lose, in as in opposite of out, courts, plural, and the number 1.com?
At gmail.com. .com and then gmail.com, yeah. Mm-hmm. Winincourts.com, correct?
Winincourts1 at gmail.com.
At gmail.com, yeah.
Okay, but what's the website address?
Winincourts.com, right?
Correct.
Yeah, Winincourts.
The website address is winincourtnow.com.
Winincourtnow.com.
Winincourtnow.com. Okay, all right.
Ron, let me ask you a question. So you've been doing this for 15 years. Not to interrupt you, Coach, but what state are you calling from? Ohio. Okay. Now, how have you been able to put this off for 15 years? Because that's really a feat. I'm really amazed at that. I only was able to do 10 years. How are you able to do 15 years?
Baby, you're just a baby.
I know I'm a baby. I gave up. I gave up after 10 years of my life. Can you tell me how you do 15 years and how you're going on in the future?
Well, for the first few years, I did have an attorney helping out on a contingency basis. When back in the day, when there was some thought that these would be, personal injury-like type cases where you could go in and sue and get damages. So he was willing to take it on that basis. That tide sort of change. This was around 2005, 6, 7, somewhere in there. And then we so that we countersued finally. I mean, I'll just real quickly say.
Yeah, I understand. Like a summary of it. Yeah, go ahead.
Yeah, when it very first started, I had an attorney who knew none of this stuff, right? So that was typical back, especially in
they
the
pretend
early.
They don't.
They didn't know anything, and so he's treating it like a typical foreclosure. And so I got into a summary judgment. As you know, once you get into that, it becomes harder to undo it. But anyway, so went through years of that. Then I kind of benefited from that whole national mortgage foreclosure period, from roughly 2010, 2011 up to 2016, where literally nothing happened. I think, that's when JP Morgan and some of those others were getting slapped by the government and had the national mortgage settlement, et cetera. And then in 2016, another bank came in, a trustee, pretender, lender type situation came in, and I've been fighting them ever since. And it's just been a continual series of TILA complaint in federal court and bankruptcy, actually 2 bankruptcies.
Oh, we did do a bankruptcy.
The documents are completely bogus. They haven't even really filed any documents.
Well,
but anyway.
Ron, now let's Coach, let's take him through his case. Now, what did he do right and what did he do wrong?
Well,
listen, Ron.
Well, it's, to be honest with you, Gene, it's hard to say that he did anything wrong.
Right.
Okay. Now,
but I mean, he maybe could have stopped it quicker or sooner.
Well, so for me, I have a non-conventional process, and then there's the conventional process. So he fought in the conventional process, and he fought his ass off. I can just tell by listening to all the things that he said and went through 2 bankruptcies, and but the problem with that process is that process, the conventional foreclosure defense process, was designed by the same attorneys that's trying to steal your property. Now, no offense to Ron, because he's hard working. He worked his ass off to get to still be in his house. That is the #1 goal, to do whatever you need to do to get to stay in your house.
Right.
So,
and actually, that's another question, because it's 2 different attorneys. The original attorney has long gone, although they're still around, I think. But I mean, they're not involved in the case. A new group came in 2016. So, how does that affect things?
Well, what I teach people is to focus on the attorney that's in your face, and that's it. The attorney and the law firm. And the reason we do that, in my perfect world, it's only 3 people on your lawsuit. It's either the petition or the one that's forcing you into court right now. Okay. And then that attorney's law firm. And then the last servicer. Those are the only 3 people that I like to have. Now, there's occasions where you have to add more or whatever, but I always have it reserved the right to amend. That way you can add more people later if you need to. In the beginning, the more people you have, the more complicated it is for you.
About that, right? Yep.
And if you have too many people, and all those people make phone calls to get together, and they file their stuff at different times, and they make you jump through all these hoops to respond to all of them. If you miss one, they're going to move to dismiss the whole thing, because they're all working together against you. If you only add 3 people on there, then what you're doing is you're forcing that attorney to take the responsibility for everybody else's crimes. So you create a little bit of a rift in the program. So the attorneys, they're cowards anyway, okay? So they're over here thinking, well, why should I take the heat for all the stuff that they're done? That's ridiculous. You guys are throwing me out too, and then you got this other group of fools over here that already got their money saying, dude, you need to go shut your face up and get in there and get this handled. You need to get under control. Well, after a certain period of time, those other group over here is going to start visualizing the shared liability, and then they're going to want to cut the tie and make that attorney make a deal so they all don't have to face a liability.
You understand that, Ron? The other thing is, I want to add to this too. The longer it takes them, and Guy and I've talked about this, the longer it takes them to get you out of your home, it's more of a troublesome thing to them. They want it cut and dry and in and out. They want that. They want that home for whatever reason, and they're willing to do whatever it takes. If you go 10, 15 years like you're going, I mean, I like I said, I give it up to you, but I also don't understand the way they keep working it. I would, as an attorney, if I was on the other side, I would like, oh, let's get in and out. If we can't get in and out, let's get some other stupid attorney to get in there and do it. And that's what he's talking about. So they're not going to take the fall for all the other problems they created or all the fraud that they created, right? And you're in the middle of that.
Yes,
so
yes, he is in the middle of it. And as a matter of fact, Gene, you're absolutely right on that. But let me clarify that just a little bit.
Go ahead.
Okay, what's going to happen is the attorney's not going to want to take the fall, and the attorney is going to want to make a deal. And that's how you back them in the corner. The attorney's going to want to make a deal. So the #1 thing that we teach, Ron, is to put that attorney who signed the document or who's dragging you in court on your document as the #1 defendant, and their law firm second. And
so what you're saying, just so I'm clear with what you're saying, is I have to file an offensive lawsuit at this point in order to submit that
Absolutely.
just through a motion.
Because as long as you file stuff in the case they have against you, they have control. And this is what I teach people how to do. You want to put yourself in a position for your appeal at the gate. And you do that by having an attorney listed as the number one defendant. And so what happens is, if you use my documents, my lawsuit package, what happens is, if the attorney's listed as number one defendant, the attorney can't litigate a case they're a party to. They can't represent themselves. And this is one thing that most people don't understand or know. The attorney also can't go into court pro se, because the court rules will not allow a corporation to go into court pro se. So now the attorney has to hire outside counsel. And when they contact the outside counsel, the outside attorneys find out that you're suing them for illegally collecting on alleged debt, for illegally foreclosing, acting as a third-party debt collector with no standing. And once the outside attorneys find out that's what's going on, they don't want to help. And the reason they don't want to help, in my opinion, is because they're doing the same thing. And they know that you know the cat's out of the bag, and they don't want nothing to do with it. So now the judge has to allow the attorneys to go into court and represent themselves and the law firm, because they can't find anybody. Yeah. So we got a nice document to strike the attorney's notice of appearance. And we're striking the notice of appearance because the local rules will not allow the attorney to go into court pro se, representing their own law firm and stuff. And if the judge allows that, then that's perfect for your appeal.
Right.
And that's perfect to sue the judge. So at the end of the day, it don't matter if you're suing the judge, if you're suing the clerk, as long as you're suing somebody for what they're doing to you. Does that make sense?
An action in federal court a month or so ago, and listed several defendants and was alleging specific violations that I'm not sure I want to get into right here right now. But because this had such a history, the federal judge took one look at it and dismissed it sua sponte. In other words, under the heading of it's just a frivolous filing, basically, because they made a knee-jerk reaction that all of these issues had been already adjudicated at one level or another. First of all, they shouldn't be bringing other cases that are not within the four corners of the complaint into their sphere of knowledge on that. But it was a whole new claim that I was trying to assert. It wasn't this claim that you're talking about, but it was a whole other claim that just emerged in the past several months as related to the bankruptcy. So I tried doing that. I didn't sue the attorney. I sued the law firm, not the attorney specifically, but it didn't even get to the point of them filing an appearance because the judge dismissed it in 8 days or something. It was quite amazing.
Well, if you're in my program, then we have the documents you need to address all that. So so the way I roll is we like to address stuff in court that they don't want to talk about. Mm-hmm. So when you're addressing stuff they don't want to talk about, it creates a whole different program. So you can't really compare. I mean, no offense or anything, but what we do to what other people have already done because of the way, I mean, for instance, and I'm just going to throw this out there for you and everybody else listening. For instance, the number one thing that I would challenge if I was facing a judicial foreclosure is the fact that the statute that they are using for the judicial foreclosure is not a valid law. A statute is not a valid law. Statutes, codes, and ordinance are rules. And I'll tell you why. The state constitution mandates that for something to be a valid law, it has to have three elements. It has to have a title, it has to have a body, and most important, it has to be enacted. And statutes and codes do not have the enacting clause. And the reason why the enacting clause is the most important thing, because the enacting clause tells people from what authority the law comes from and who's subject to following it. Now, these people make ordinances and codes, and they call them laws. They're not laws. A corporation cannot make its own laws. They can make rules and policies, but not laws. That is one of the main things that I would be challenging. And because that statute, if that statute the court's using to steal your property is not a valid law, does not have the necessary elements to be considered a valid law, it can't provide jurisdiction to the court. Bam. And the most important thing is to always be challenging the court's jurisdiction. Because if you go into court and you argue the banking system and all that stuff, that's what they want you to argue, because they know that they're going to be able to do what they're going to do in the end, throw you out in the end, because that's not what your situation is about. Your situation is about the attorney trying to steal your property. And most people don't even have the attorney listed on their lawsuit anyplace.
Ron, I want to ask you a question. How did you find us?
How did I find you? A friend of mine that we've been sort of going through some of these same things together said, "Hey, you really got to listen to this guy."
Yeah, this guy is amazing. Okay. I mean, he gives it to you straight. I mean, I just saw on his post the other day that 2 people that do fraud disclosure or whatever apologize to him. You know what I'm talking about?
Yeah.
Coach
sorry.
Neighbors.
Wait, say it again. Something cut out. Go ahead.
Coach Neighbors knows who I'm talking about. There was 2 guys that do fraud disclosure or whatever, and they were calling him a fraud, and now they just apologized to him. That was huge, because they're seeing that he is the real deal. Okay. What he's telling you is stuff that he knows. And believe me, I wish I had him years ago, because I would have still never had an issue where they did a loan modification on my house and made me pay them an extra $130,000 and made me wait 30 years. I'm 59. What am I going to do? Wait till I'm like 100 something? So these people are evil bastards. I have to say it like that. You know that. But every case, even though it's different, is similar, the way they handle it. Coach Neighbors and I talk about this all the time. If everybody had the right information and tools to take them down or just stop them, that's what we need to do. And you're on the right track. Just keep on doing what you're doing. Follow his advice, check out his website, and seek him out.
Yeah, we'll do it.
Okay. Any other comments? Good.
No,
Coach Neighbors?
Send me an email, Ron.
Good work. You guys are doing good stuff.
And we're the only ones doing it, because no other radio station does what we do. Go ahead, Coach Neighbors. Go ahead.
That's
He's having
associated with anybody that's showing people how to kick attorneys' butts.
Love it.
Yeah. All right, guys. Thanks so much. Appreciate you.
Thank you,
Thanks,
Ron.
Ron.
Thank you for your call.
You bet.
Okay. Great call.
Yes.
You know,
Okay, let's get into
back to
our
school,
things.
Coach.
We can make sure that we have enough time to finish this.
you have 15 minutes.
Okay, so most pro se cases, attorneys will often file a motion to dismiss for failure to state a claim under Federal Rules of Procedure 12B-6. Now, one of the things that I want to tell you guys is, when you get something from the court, don't call me immediately freaked out. Review it, study it, look up any words in it that you don't understand. Make sure you understand what you got, or at least what you think it is, and figure out what your plan should be. Then if you have questions, you can hit me up and let me know what's going on. Then I can kind of tell you where you're at. I get frustrated when people call me and say, "Hey, I just got this. What do I do?" No, that's not my job. I'm not an attorney. My job is not to make it easy for you. Okay. So when you get something, if you have questions about the service, or you have questions about how long it is that they have to respond, go to the Federal Rules of Civil Procedure and look it up, because you have to know. If you don't know how long they have to respond, then the judge is going to take over and dismiss your stuff, and that's what we have happening with the jurisdictional challenge with an affidavit. So go to Federal Rules of Civil Procedure. Right now, we're going to talk about 12B-6. So the Rule 12B-6 in subpart of the Federal Rules of Civil Procedure, Rule 12B, which states in general that all defenses must be put in the defendant's answers. But it also gives defendants an option to raise some additional defenses by motion before an answer is filed. Now, it doesn't say this in their rules, but you can also raise a defense of lack of jurisdiction. And that's what I always do at the gate, because if they can't get past that, they're going to have a whole lot of trouble with all the stuff they got in their stuff they want to stick in your face. So that's one thing that you need to remember. So therefore, defendants can, instead of answering right away, raise one or more of the Rule 12B defenses by motion, and only if the defendants lose that motion will they have to answer to the complaint. So one of the defenses in Rule 12B allows you to raise a motion is the defense set out in Rule 12B6, failure to state a claim upon which relief can be granted. Now, in my opinion, this is BS, but it's part of that game. And most of the people that use my stuff, we get past this because of the information that we have. According to this rule, and we'll cover it down here later, if you have enough information where the judge can look at that and say, okay, well, this person has a really good chance of causing some problems, then they shouldn't dismiss it under 12B. But we already know they don't follow the rules. And this is one of the things that I struggle with when people tell me, oh, I got 10 days, or I got this. No, you don't, because they're not going to follow the rules. If they were following the rules, they wouldn't be in your face right now. So people need to keep that in mind. So first thing we're going to go to, in order to defend against a motion to dismiss or failure to state a claim upon relief can be granted, we must first understand what a claim is under the Federal Rules of Civil Procedure. And I usually don't follow all of their stuff because I'm hard-headed and I think their stuff is BS. But hey, this is one of the things that they're using to try and dismiss our stuff. And I'm like, I know we can smash it. So we finna smash it. So a claim for relief is defined under Rule 8A as having 3 elements: a short and plain statement of the grounds that provide jurisdiction to the court. That has to be in every civil claim. A short and plain statement of the claim showing that the pleader is entitled to relief, and a demand for judgment for relief the pleader seeking. So those things have to be, that's what they're talking about when they ask for, when they're saying that you need to state a claim for release or that you fail to state a claim for relief. What this means is that the complaint must have statements that support the court's jurisdiction. For example, this case is brought to enforce constitutional rights under 42 U.S.C. 1983 filing. And then you have the allegation to support the claim that you're making and what your relief is going to be. So the policy behind these rules is to simplify the pleadings and not put up technical barriers to relief. So that's kind of cool. But, you know, most of us don't look into these rules or whatever, or we pull them open and we look at them and we get intimidated because there are so many. And so I'm going to tell you, just like I tell people who open up my non-judicial lawsuit package, which had 16 documents, but after we added the reconsideration package against the magistrate judge, now I think there's 24 documents in it. So what I tell people when they open it up is don't be freaking out, okay? You can only do one at a time, one step at a time, one document at a time. So that's the same thing here, one at a time. So this means a short, plain statement of the facts that make up the claim. For example, you must put in statements that show what happened to you, that you were seriously injured, and the mental state element required by the courts, that the defendant acted with deliberate indifference to the Constitution or the law or whatever the problem is. In this case, it would be the Constitution and the law. Now, this is something that I don't think I have this in my foreclosure lawsuit packages. So when I get done with this, I'm going to have to make some changes to some things. And I'm also going to add this, I'm going to add this as a lecture to the online course. So the students in the online course will have opportunity to perfect their stuff in the same manner that the attorneys like to have it done. We're going to do it the same way attorneys like to do it, and we're going to stick it right up in their face. So that's how we roll over here. So if you fail to state deliberate indifference in your complaint, it will be dismissed for failure to state a claim, especially if you're claiming a constitutional violation. And that I didn't know. So I've been working on this for the last 3.5 or 4 days, and I have learned a lot. And one of the things that I'm figuring out is this is a whole lot easier than what I've been doing. So I'm going to spend a little more time looking at their rules and figuring out how to make sure that they can't use them against the people that invest in my program. So also be sure to include how the defendants did. Now, I'm going to put this together as a checklist with all these notes on it. And I'm going to send it over to Gene so they can just like put it on the show like we did, put it on their station for, $10 or something, or $5, whatever the radio station decides, to help those guys raise a little money to make it through this COVID-19 crap that we're all dealing with. And this will give you everything I'm talking about today will be outlined on this document. So you can take this document and look at it while you're writing up your claim. And that's what I would suggest that you do, so that you can tweak things to have it the way they're saying to put it here. And I'll tell you this, with the success that we've had with my documents already, by adding this to it, bam, it's going to be nice. So
Papers takes on the world.
So after putting in the factual allegations, you can say something like, these facts show how the defendants violated the plaintiff's constitutional rights under the color of the law by real estate deed fraud, and violated real estate deed fraud laws, or etc. If you have included in your jurisdictional allegation the facts of what the defendants did, allegations of deliberate indifference, or any necessary mental state, and requests for relief, money damages or injunctions, then you have created a claim. So when they tell us we haven't created a claim for relief, we freak out, but now you see that these are simple freaking things that you need to do to put in there to alleviate that problem. They're not that complicated. And once you put these things in there, you will be in a position to make the attorneys respond, because the judge won't be able to dismiss your stuff. Now, the courts do not generally favor Rule 12B motions to dismiss. And the reason is because the policies of the federal rules is to allow the case to proceed if the plaintiff has any reasonable chance of obtaining relief. Now, that's in a normal situation. When you come to the court with my stuff and they don't want to talk about it, then they're not going to be worried about this. They're going to use any excuse they can to try and get you out of their face. Even though you're in federal court, the federal court don't really like having state courts crap in their face, especially if you're showing people how to kick the bank's butt or the attorney's butt. Now, I've had people go to file their stuff and the clerk will tell them, oh, no, you have this wrong. I'm going to change this. The attorney's not the number one defendant. And of course, my people, the first thing to come out of their mouth is, oh, wait a minute. Now, I have a copy of the petition here that's attached to this as an exhibit. And if you'll look right here on the last page, the attorney's signature is the only signature on here. See, flip it up. Well, no, the bank hasn't signed here nowhere. So I don't understand how the attorney can put the bank's the one suing me when the attorney is the only one that signed and the bank is not involved in it. Well, the clerk shut up then and went and sat down. She didn't have no more to say after that. So the Rule 12B6 motion argues that based on what is said, the plaintiff could not possibly be entitled to relief. Now, courts do not determine whether the facts as stated by the plaintiffs are true, but instead assume truth of the plaintiff's factual statements and decide whether you have a claim or not that could lead to relief. Now, the U.S. Supreme Court has stated the issue is not whether a plaintiff will ultimately prevail, but whether the claimant is entitled to offer evidence in support of his claim. So the complaint should not be dismissed for failure to state a claim unless it appears beyond that the plaintiff, beyond a doubt that the plaintiff cannot prove no set of facts in support of his claim, which would entitle him to relief. That's Clooney versus Gibbons. I'll include this case law in the sheet and the check sheet that I provide to Gene that you guys can get a chance to take a look at.
Sure.
So, and these cases are nice to have because you can use them if they do dismiss your claim for failure to state a claim and you stated a claim properly, and they do that too because they don't do things the way they should. So don't be surprised. If you're dismissed without, if dismissal without leave to amend is improper, unless it is clear the complaint could not be saved by an amendment, and that's Snyder versus California DLC. So some points to consider, and this part really got my attention. So first, Rule 12B motion should not be include any additional factual material by the defendants. Now listen up. If the defendants do add additional facts, it is likely that the motion will be treated as a Rule 12B6 motion. It's likely that the motion will be treated not as a Rule 12B6 motion, but as a motion for summary judgment. Now, this is important because if they trick you to throw people under the bus in court because you show up ready to argue the wrong shit. If they add stuff to the motion and turn it into a motion for summary judgment, then what you need to do is demand the court set another date so you can go home and prepare to respond to the motion for summary judgment. Most people don't know that. So what happens when they do that in court, they slick like turn it into a motion for summary judgment, and you're there ready to argue the other motion. And yeah, you see how that goes. And the attorney and the judges look at each other, smile, slam the hammer down, because now you need to go and pack. Because you didn't ask for that time that you needed because they changed the motion on you by adding stuff to it and you didn't know. It's sad, but they throw us under the bus with this kind of crap all the time. So this means that in deciding a Rule 12B motion against a pro se litigant, the court is supposed to look even more carefully to see whether any set of facts consistent with the complaint could be proven. And if so, the motion should be denied. Now, this is why most of my stuff goes through without this problem, is because the facts that we put in it, they don't want to talk about because they know the facts are going to kill them in court. It becomes a summary judgment motion when the matters are set aside when matters outside of the pleadings are presented to the court. The motion shall be treated as one for summary judgment. And the first thing that you need to do, like I just said, the motion for summary judgment is governed under Rule 56 of the Federal Rules of Civil Procedure. So you need to go review those rules so you'll know how to answer. And basically in a summary judgment motion, that's granted if the person demanding the summary judgment can prove that there are no issues on the table that need to be heard by the court or in trial. So, and that's easy to block if you know that they're doing that to you and you have your time to study it. So you should be allowed to comply with the Rule 56. And that's what you want to do. You want to ask the court for additional time so that you can go and prepare yourself for the motion that they're actually sticking in your face. So if the defendants include factual material along with the Rule 12B motion, you must object and demand the court to allow you additional time to respond to the motion for summary judgment. So that's kind of in a nutshell, real quick on how that goes. I'm also going to post what I'm going to provide for Gene in the Facebook page.
Thank you, sir.
It's in the group, and then I'll talk to my YouTube followers later on. And then Gene, I'll provide you a copy of what we talked about today real quick so that you can set it up.
Sure, my wife wants me to take her back to work.
I want the notes.
A couple minutes. Thank you, buddy. I what a great show. Great calls. See, the word's spreading. And that's what I want. Listen, I also want to say, listen, if we can get a couple sponsors for this show, this will be a huger or bigger show, not huger, bigger show than we're trying to make it. So we need sponsors, guys. If you hear what Coach says and you like what Coach says, you can reach out to me at admin@hamiltonradio.net. You can reach out to him at, what is it, winningcourts1@gmail.com, right?
Yep.
Okay, so do that, guys, and we'll talk about, your sponsorship, but this is a show that not everybody wants to get involved with. Understand what we're doing here. We're going against the courts. We're trying to keep people's homes. We're fighting for home veterans. We're fighting for everybody that wants to keep their homes. And now businesses can get involved. A lot of businesses out there in COVID are going to lose their business. This can't happen. Let us help you. Thank you.